Alright, hello Year 11 Legal Studies students, and welcome to AOS3, where we're going to be looking at civil liability. This is very similar to what we looked at with criminal law, but just with a civil lens, where it's not about someone doing something against the Crimes Act, it's about someone infringing upon someone else's rights, and basically all the laws involved with that. We're going to specifically look at negligence and defamation in as much detail as we possibly can. Apologies if I pause or go off for a little bit during this video at any point in time. I currently have a co-pilot who is swinging down over here, just hanging out, while you guys, if you're in my Year 11 class, are doing your first part of your SAC for Areas Day 2. So we're going to get started on this and get straight to it. So civil liability. So first up, we're going to go straight into what. Alright, so we're going to look at the purposes of civil law first. So why we have civil law and what it's attempting to do. So through the civil system, statute laws and common law help establish the law. That's how all of our laws are created. The courts decide the law, so the courts decide what is going to occur when there is a civil dispute. They look at previous laws, they look at case law, and they look at statute law to see how, and they look at court judgments to see how it's been applied in the past, and then enforces the law through ensuring that remedies are carried out. So remedies are going to be through a whole range of things that we'll get to later in the topic, whether it be damages in the form of money, whether it be finishing a contract, whether it be an injunction. There are many different ways in which civil disputes can be resolved. So the four key purposes we have for civil law is that they achieve social cohesion. They protect the rights of individuals. We have many rights that need to be protected, and a lot of people are not aware of them. And it's important to know them in case they are being infringed. They ensure that people have the opportunity to resolve disputes, and they provide a mechanism to seek compensation if you have been wronged. So these come up in a variety of different ways, and we're going to give some examples of them throughout. We also have a lot of different types of civil law. So we're specifically going to look at negligence and defamation, which I'll highlight now as they tend to be the go-tos, but we might also touch on some of the other ones briefly as we go. In the old study design, like years and years ago, to show my age, it's like 4 years ago, so not that old. We used to actually look at some of these in more detail. We'd have an area study dedicated to doing an in-depth analysis of one of them, where I know I used to look at contract law or family law. I used to show contract law solely because there was one scene in Suits that explained contracts really well, that I could show in class and make it seem like I was cooler than I actually was. So we've got some key concepts to civil law overall, and we're going to look through these one by one on the following slides. So don't freak out that there's a lot more slides to go. It's just we're going to look at the fact that it needs to be breached, there needs to be causation, there needs to be loss, there needs to be limitations of actions, there needs to be burden of proof and a standard of proof, and we'll look at what they are overall. So in breach, in civil claims, the plaintiff normally has to prove that the defendant has failed to observe a law or obligation. It could be a breach of an agreement the plaintiff and defendant had entered into, or a breach of a duty of care. So it could be, I used an example last year when I was doing this, where just outside this window over here, we had a fence that blew over during a storm because the fence was old and garbage. And we kind of had to work out, like we were trying to work out who owned the land behind our house, because when we were going to get a new fence, contractually, they had to pay for half. And if they refused to pay for half, then they would have been in breach of an agreement, and we would have had to work that out. That gets into some of the contractual type things. It'd be the same like if you paid a tradesperson to do something and they didn't either do it to the standard they were supposed to, or they just didn't do the whole job. They would be in breach of an agreement, and you'd be able to take civil action against them. Other than that, there's also a breach of a duty of care, so owed by a teacher to their students. The usual examples I use don't really apply right now, because I used to always use the example that if I don't sign your diary when you go to the bathroom, or if I let you out of class early, which you could be, hopefully you're not in the bathroom right now when you're watching this, that would be incredibly weird, but you could get up and walk away right now and I wouldn't know. Please don't do that. Keep listening to me. I have interesting legal information to tell you. But if that happened at school and I let you out of class without permission, I let you out of class without a good reason why, or without supervising when I have a duty of care to you within those hours. That could be a breach of duty of care. If you got injured, then you could take action against me and the Department of Education, which I don't want to happen because I don't have that much money and I don't want to be sued. Next one is causation. So the plaintiff needs to prove that this breach caused or resulted in the harm to the plaintiff. So there needs to be a causal link between the defendant's breach and the plaintiff's harm. If there was an intervening event that occurred after the defendant's breach and that event caused the harm, the defendant will not be liable. So if we use the example of me letting you out of class early and you were then harmed, if you walked out of class, climbed the fence and then jumped off the top, that's not really me that's caused that harm to you. Like, although I've breached my duty of care, you've done something incredibly dumb that's caused your harm. So then that causal link might not be there, that my breach might not have caused your harm. It may have contributed to it, because if I didn't do that, you wouldn't have gone out and harmed yourself, but you contributed to that in some way, and therefore the causation might not be totally there, and I might not be liable. Then there also needs to be some kind of loss. So there can be many different types of loss. There can be economic loss if you've lost wages or you have medical expenses. If there's property damage, if there's personal injury, if there's pain and suffering, or loss of amenities, so if you lose your enjoyment of life, these are all things that can come into account here. I used to always use the example that I was in a big car accident 3 or 4 years ago now, and a lot of people used to ask me why I didn't take action against the driver, because it was a serious accident. I was not really that injured, but I could have been seriously injured. Why didn't I take action against them? Firstly, I didn't really suffer that much loss. I lost a drink bottle, and I got a little burn on my arm. Not that big of a deal in the grand scheme of things, when I thought the time and effort and the anxiety and stress that would have been of going through court and going through all those processes would not have actually brought me any benefit if I got some kind of financial benefit from it. And then I was also worried the kind of person that would do a hit and run on a car probably didn't have the economic situation to then pay those court costs, and it might have all been for nothing. So you need to suffer some kind of loss if you're going to take civil action. There are limitations of actions though, so if you have been wronged, your rights have been infringed, if you've been harmed, you're in some way. In Victoria, the limit for most claims is 6 years, although in some cases the limit can be extended. So if you're wronged this year and then in 2027 you start being worried about it and want to take action about it, that's too late. You can't, there can be some situations where it is relevant, but for the most part at 6 years there'll be extenuating circumstances where it might, so there might be a way if you're acting negligent now where in 10 years they discover that that's a serious issue and there needs to be reparations for the people who were harmed from that years ago. But for the most part, it's 6 years, because if after 7 years you decide that your rights were infringed and you want to take action, it probably wasn't actually impacting you that much if you waited that long. Then the last two things we're going to talk about are the burden of proof. So the onus or responsibility of proving the facts lies with the plaintiff, as they made the allegation against the defendant. So if you were if you sued your neighbor because they were making too much noise and they're partying every night and they're making your social isolation a whole lot more difficult, you need it's up to you to prove that. So you need to have evidence against that. So you probably need to keep a diary, you need to take videos, you need to take recordings. So then when you got to court, you could prove that it's most likely that they have actually been doing that. And then lastly, we've got the standard of proof, so which is the degree to which a civil case must be proven, which, as you should know, because it's been the first topic and we still talk about it fairly often, is on the balance of probabilities, which means that it's most likely that the plaintiff is more likely to be right. So the reason why it's the balance of probabilities and not beyond reasonable doubt is because in these cases, it's one person, it's kind of he said versus she said, or he said versus he said, or she said versus she said. Any gender can sue any gender, but it's all about sometimes in these situations, it's about who's kind of most likely to be right, because when people are giving their experience and talking about how they've been impacted emotionally, mentally, etc., it can be really hard to actually get 100% damning evidence. It's not like murder where there is a knife that matches the wound, which has fingerprints and DNA on it. If you haven't been sleeping because your neighbor plays loud music at night, it's not really like, you can't do a brain scan and be like, all right, well, they slept 4 hours this night, 3 hours this night, 3 hours just from their brain scan. That doesn't work. So you need to have evidence for that, and then have that evidence, have either a judge or a jury believe that evidence is the most likely to be accurate. So these are all the kind of main parts of what makes up civil law. And so, a bit of a rhetorical question here. Do you think the standard of proof should be the same in civil and criminal cases? Why or why not? To give you the answer, you do not believe they should be the same because of what we just talked about, with the fact that in a civil case, you can't perfectly prove that one person's in the right or wrong, because some of the evidence is going to be circumstantial and it's harder to get that definitive proof. All right, so that's the end of this video. Pretty short, punchy to the point. I want these to all be around under 15 minutes, if can be. So thank you for watching. I hope this was beneficial to you. Apologies, I'm talking quick in this one. I'm trying to get things done because the class is doing a SAC at the same time and I want to respond to their questions. If there's anything else I can do for you, either comment below this video, send me a message, send me an email. I'm more than happy to help. And I will see you next time when we start looking at some more specific parts of tort law. Thank you. Bye.